Welcome to the award-winning Consumer Finance Monitor podcast, where we explore important new developments in the world of consumer financial services and what they mean for your business, your customers, and the industry. This is a weekly show brought to you by the Consumer Financial Services Group at the Ballard Spahr law firm. And I'm your host, Alan Kaplinski, the former practice group leader for 25 years, and now senior counsel of the Consumer Financial Services Group at Ballard Spahr. And I'll be moderating today's program. For those of you who want even more information, don't forget about our blog, consumerfinancemonitor.com. We've hosted our blog since 2011. So there's a lot of relevant industry content there. We also regularly host webinars on subjects of interest to those in the industry. So to subscribe to our blog or to get on the list for our webinars, please visit us at ballardspahr.com. And if you like our podcast, please let us know about it. You can leave us a review on Apple Podcasts, YouTube, Spotify, or wherever you get your podcasts. Also, please let us know if you have any ideas for other topics that we should consider covering or speakers that we should consider inviting as guests on our program. Today's podcast episode is a repurposed webinar that we did on March 24th entitled CFPB Developments, Everything You Want to Know About the CFPB as Things Stand Today. This is part 2 of that webinar, where we will address the status of CFPB enforcement investigations and litigation, the status of CFPB legislative reform, the development at other federal and state agencies with jurisdiction over entities in the consumer financial services business, and what the agency will look like during the remainder of President Trump's term and beyond. In part 1 of our repurposed webinar, which we produced last Thursday, we covered the chronology of initiatives by the acting directors since Rohit Chopra was fired as CFPB director, the status of lawsuits that were filed against the acting director and others by the labor unions representing CFPB employees and others in the Federal District Court for the District of Columbia and by the City of Baltimore and others in the Federal District Court for the District of Maryland, challenging the effort by the Trump administration to shut down or minimize the CFPB. As I noticed in last week's introduction to our podcast show, on Friday, March 28th, Judge Amy Berman Jackson issued a 112-page opinion and a 3-page order in the lawsuit filed by the labor unions representing the CFPB against the acting director of the CFPB. Judge Jackson granted a motion for preliminary injunction, which in broad terms enjoined the defendants from continuing to dismantle the CFPB without congressional authorization to do so. Okay, I'm going to introduce our 2 very special guests for the program today. First of all, Jon Hill. Jon is a senior banking reporter for Law360, where he covers high-stakes court fights and policy debates shaping the future of financial services. Previously, he has written for outlets including The Economist and The Street. And as a counsel on foreign relations researcher, he assisted Sebastian Mallaby on his award-winning 2016 biography of former Federal Reserve Board Chairman Alan Greenspan. He graduated from Columbia University, majoring in economics and political science. And then I'd like to introduce Evan Weinberger. Evan Weinberger has covered banking and fintech for Bloomberg Law since 2018. He's also covered the sector at Law360. He preceded Jon Hill there. He's previously reported from Cambodia, Rwanda, Uganda, Burundi, and Cameroon. He's a graduate of Vassar College and the NYU Arthur C. Carter School of Journalism. So we're very, very pleased to have Jon and Evan as our special guests. And then the rest of the team, I'm not going to spend time personally introducing, but it's people who regularly appear on our webinars. They're all in the Consumer Financial Services Group: Rich Andriano, John Culhane, Tom Burke, and Joseph Schuster. The next thing on the agenda is a discussion of enforcement investigations and litigation. And going to turn the program over to Tom Burke. And Tom, are you there?
I am here. Can you see me on?
Yes, I can. Okay. So there are, at least what I understand, is that there were 38 lawsuits, enforcement lawsuits that have been brought by the CFPB that were pending at the time that Rohit Chopra resigned. And we've seen a lot of things covered in the media. Evan and Jon Hill have talked about a lot of the things that have gone on. But we wanted to make sure that we could give a complete picture of what's happening with respect to the 38 lawsuits. So go ahead, Tom.
Absolutely. Thanks, Alan. So as many of the Bureau watchers here may know, the Bureau actually maintains on its website, it was briefly taken down during the interregnum period, but it's back up now. They maintain a tracker of all of their enforcement litigation. And you can filter that in various ways, including by pending litigation, resolved on a consent decree, or whatever the case may be. And we monitor the pending litigation, some of which involves our clients, some of which is of general interest. And as Alan mentioned, there have been 38 actions listed as pending. Now, the Bureau's listing of that may or may not be perfectly accurate. I have noticed actions that do not appear in that tracker for various reasons, but we think that it is substantially complete, as you might say. So what kind of suits fall into that big bucket of 38 active matters? There are a handful of what I'll call enforcement legacy matters that were filed in 2020 or earlier that had already reached a judgment or were on an appeal, sometimes stipulated consent judgments that had disputes between the parties about whether the defendant was complying with the judgment. And there were about 7 of those. Those are not, by and large, of particular interest here because although they are nominally active, they're not really. There were another 15 matters that were filed between 2021 and 2023, most of which were in various stages of open litigation, such as motion practice or discovery. Many of you know that Bureau litigation often involves the filing of motions to dismiss. They tend to be extremely complicated, lengthy motions. It's not uncommon for them to take years for the court to decide those motions, and then potentially years on interlocutory appeal to a federal appellate court. And so that slows things down as well. There were another 15 or so matters filed in 2024 and early 2025. And that includes what I'll characterize as a wave of docket clearing enforcement actions, which were matters that the Bureau had been probably hanging on to in late stage investigations. And in anticipation of the turnover to the Trump administration after the November election outcome, they decided that they were going to move forward with those suits. And what you may also know is that historically, the Bureau has virtually never dismissed actions because of a change in political will or a reevaluation of the viability of its theory. So, in other words, an outgoing director could file a bunch of actions in the hope to kind of lock those in and bind their predecessor based on bureau precedent. And so Director Chopra in his last 2 or 3 months took a number of very big swings on matters that presumably they tried to settle and then were not able to settle, didn't want them to die on the vine. So what's happened with all of those cases? Well, many of you who pay attention to the Bureau will remember February 27th and 28th, which was a day when 9 of those actions were abruptly, voluntarily dismissed with prejudice by the Bureau in what was a historic and unprecedented move. Now, it was a little bit awkward for the Bureau because it happened simultaneously. Those docket entries came down simultaneously with Jonathan McKernan's congressional testimony. So he, on the one hand, is answering Elizabeth Warren's questions about maintaining the Bureau's enforcement profile, and these actions are being literally dismissed at the exact same time that he's testifying. So that was an interesting warning. In other matters, the Bureau hasn't gone quite that far. They moved to the court to stay, I believe, 10 cases, and they had mixed results on that. As you know, the Bureau is not allowed to unilaterally just stop litigating and pause things. You have to get the court's approval. So in 5 instances, the court granted those motions to stay, and those cases are on hiatus right now while the Bureau reevaluates what it is going to do. In 2 cases, the stay was denied, and in 2 cases, the motion for a stay is pending. Now, what's the Bureau doing while those cases are stayed? Maybe they are reevaluating at senior levels whether there is political will, so to speak. Maybe they're waiting for the staffing picture to clear up to see if they will actually have the human bodies needed to litigate those actions, either in discovery or in motion practice. So in terms of the cases that were dismissed and the trends that those dismissals show, they were largely focused on those docket clearing actions, those big swings that I referenced earlier. So the Zell suit against Chase, Wells Fargo, and Bank of America, the Capital One suit that alleged $2 billion in alleged harm relating to deposit account interest rates, and Vanderbilt mortgage, a case in which there was an accusation of mortgages in connection with manufactured homes where the consumers allegedly could not afford the mortgages that they were getting. All those cases were dismissed. A case that we at Ballard represented one of the parties in, Rocket Homes was the primary defendant. There was another defendant, a real estate brokerage, and that case involved some novel theories of liability under RESPA, the Real Estate Settlement Practices Act. And we were pleased to see that the Bureau's, in our view, overreaching interpretation of RESPA was not adopted by the new administration. So what is actively still being litigated? In other words, the other half of what's left that's not been stayed or dismissed. A couple interesting things. The first is that in cases where you have states as co-plaintiffs, those have largely not been stayed or dismissed. So as you know, the Bureau litigates many of its matters solo. However, it also brings in, the degree of coordination can vary, but you also see instances where the state of New York, for instance, is a co-plaintiff, maybe suing under state law, maybe also suing under the Consumer Financial Protection Act. Those cases, whether it's because the fact is that they can continue even if the Bureau were to drop its own claims, or because the states would oppose a stay, those cases have not gone anywhere yet. There's also a couple cases substantively where we're seeing some indication that the current administration is not backing away from enforcement. So, for instance, there are 2 matters, one against a company called First Cash and another against MoneyLion, both of which involved allegations of lending in violation of the Military Lending Act, that the interest rates were allegedly too high. And so you see some indication that maybe the Trump administration does not want the bad press associated with dismissing cases involving allegedly usurious interest against service members. You can imagine that the Service Members Civil Relief Act might be another area where the Bureau would not pull back its enforcement efforts. In other words, regardless of whether the Bureau's legal theory is relatively novel in those contexts, they may not want the optics of walking away from those cases. In terms of one other interesting point I'll comment on is that, of course, the Bureau is all the time settling actions in the form of consent judgments. And I'm quite sure from firsthand knowledge that the Bureau was leaning on a lot of its counterparties under investigation to settle their cases in the lead up to the November election and even afterwards, saying, hey, we're going to sue you and you can get a deal now by settlement. And a number of companies took them up on that. So you do have some consent judgments that are, 2024 or early 2025 dates that were entered. And I think some of those companies may now be getting buyer's remorse in the sense of thinking, well, gee, we could have done a lot better had we not settled and now waited to see what the Trump administration would do. Are there going to be takebacks on any of those? Meaning, will the Bureau be open to reopening any of those stipulated judgments? And would the court allow it? I don't know. Those are opening questions. I'm sure anybody in that particular limited scenario already has counsel and will be talking to them about it, but it'll be interesting to see if the Bureau reopens any of those basically closed matters. Last point with respect to investigative activity. At all times, the Bureau has its 38 or whatever enforcement actions, but it also has a much larger number of pending investigations. I assume that, these are matters that have progressed beyond supervision to the point where you're in pre-litigation enforcement activity. And those can be very worrisome and expensive to deal with. In our personal experience, those investigations stopped when the administration turned over and Chopra left. Whether and when they continue is an open question. It might depend on the subject matter area. If it's a Military Lending Act case, you might be in trouble. And it will also certainly depend on the outcome of the matter before Judge Berman and whatever appellate rulings come down following whatever she does in terms of the ability of the Bureau to scale back its activities. So that, Alan, without walking through every individual case, believe me, they're being updated by the day in terms of the things happening in these matters. That's the summary of where we are in enforcement.
Yeah. The only thing, Tom, that I would add, and this is just an observation, and that is that any investigations or litigation that involves out-and-out scams, out-and-out fraud, where the Bureau is not pushing the envelope at all. They're going after people who, I would say it's bipartisan when it comes to attacking and eliminating companies that are engaged in out-and-out fraudulent behavior. I would think those cases will continue. But cases where the CFPB has pushed the envelope, try to, essentially apply various statutes to activities where it's not so clear that they're covered by the Truth in Lending Act, things like rent to own. And there are other kinds of things where the CFPB has pushed the envelope. I think they will eventually go away. I mean, that's just my view. Do you agree with that?
Yes, I think there's likely to be a wave 2 of dismissals in actions of that nature, where, for instance, maybe the Bureau hasn't had to make an immediate decision because there's a pending motion to dismiss and nothing is forced in their hand, but they will come around to those and some of those will be dismissed. The first category you mentioned, what I'll characterize as kind of the fly-by-night entities, they're often poorly capitalized. They often don't have the resources to litigate even if they wanted to. Out-and-out fraud, those will continue to be brought either as complaints and litigated briefly or as consent judgments.
Okay. All right. Well, thank you very much.
Before we move on, I just want to mention one other thing, too, and I'm excited to see what happens, as Tom was saying, with some of the entities that entered into stipulated judgments towards the end of the last administration, whether any of those would be revised. But one thing, I know that a number of those entities have compliance plans or redress plans that they're doing pursuant to those consent orders. And I think that is potentially an area where there is room for a little bit of movement as opposed to going too far in what's in that compliance plan or that redress plan. And many of those entities did get extensions of the timeframes that they agreed to in the consent orders of really, as those are being drafted, sticking as close as possible to the consent order. And even, I think in some instances, just staying close to the law if the consent order purports to go above the law. But I know, Tom, we've worked on a number of those. And I don't know if you had any thoughts on just actions as entities are kind of looking at those things who did enter into some of these consent orders as well.
Yeah, we've received quite a large number of questions on that, actually, in terms of, I have a consent decree and the Bureau is not responding to my questions about how I should comply with it. What do I have to do? Well, that's unfortunately not something that we can answer with a broad brush in terms of directing anyone not to follow the terms of a consent judgment. Of course, I would note that if you have a consent judgment, a court has approved it and entered it. And unilaterally deciding not to comply with it could be a real problem, even if the Bureau never does anything. So that's going to be a case-by-case basis. There may be instances where there are particularly onerous and disputed compliance provisions, and there might be a different approach. But I would just be very careful with that and consult with counsel.
Okay. Well, thank you, Tom. We have a number of people who've asked questions about, and I'm going to go back a little bit in the agenda to the regulation segment that Jon and Rich covered. And I guess my question, well, for either of the two of you, what's the status of buy now, pay later and earned wage access?
Nothing has really happened with either of them. So I guess we'll have to see where they end up. Buy now, pay later, there doesn't seem to have been any, there is litigation over it interestingly by the Financial Technology Association, but there's not been any activity in the case for some time. On the earned wage access, again, I think that's the same, that basically not much of anything has happened with that. Earned wage access was a proposed rule, not a final rule. It's probably not going forward, but there's not been any...
Director Chopra actually withdrew that one right before he was fired.
Earned wage access? I thought he withdrew over limit fees.
Nope.
No.
Pretty sure it was earned wage access.
No, he withdrew the NSF fee on over limits, but I don't think he pulled the earned wage access, although I'll check that.
Now, buy now, pay later, that was not done through, it was an interpretive rule, am I right?
It was an interpretive rule. So
is that, in order to get rid of it, it would not be necessary to go through notice and comment, would it? Wouldn't they be able?
It's in an interesting position. I think it could be withdrawn without going through notice and comment. The CFPB did take comments on it. I thought Chopra was going to reissue it as a legislative rule on the basis of the notice, on the basis of the comments received, but that didn't happen.
Okay. All right. Well, thank you. Thank you, Jon, and thank you, Evan. So we're up to the item 5 on the agenda, dealing with the status of CFPB legislative reform. This will be a very short report by me because there isn't a lot going on other than the fact that on Wednesday of this week at 10 a.m., the House Financial Services Committee will be holding a hearing entitled A New Era for the CFPB, Balancing Power and Reprioritizing Consumer Protections. If you go on the website of the House Financial Services Committee, you will see a committee memorandum. Doesn't say a lot other than it lists a bunch of bills that have already been introduced. And there are a lot of bills. There are probably about 10 bills that deal with the CFPB, that deal with various aspects of the CFPB, but none of them have moved. There's been no progress with respect to any of them at this point. The only thing I will add, and if anybody else wants to comment on this, you're certainly welcome. I think there is a real possibility that if the Republicans want to change the funding mechanism for the CFPB, they could do that through the so-called budget reconciliation process, which is the process that the Republicans are going to be using to extend the tax breaks that were given during Trump 1.0. If they wouldn't be able to get rid of the CFPB through budget reconciliation, and I don't think they can make other major changes, like changing the governance of the CFPB from a sole director to a 5-member commission. But I think they really have a realistic possibility, assuming that they can get the approval of the Senate parliamentarian to subject the CFPB to congressional appropriations. And of course, if they're able to use budget reconciliation, they only need a majority vote in the Senate. They don't need the 60 votes, and they may not, assuming that the Republicans all stick together on that, they may not need help from the Democrats, to accomplish that. So let me turn the program now over to Joseph.
I'm going to move fast through a couple of things in the interest of time, because I want to make sure that we get to our last agenda item as well for what we think is going to happen when the dust settles on all of this, what it means that the dust settles. But there's been a lot of activity even outside of the CFPB as well that I want to touch on. So we're going to touch on a number of different developments that are happening at other federal agencies, state agencies, and with states with respect to the state AG. I know Tom mentioned a little bit about what we're seeing with state AGs. The first thing I'll mention is what I have on the bottom of here is that the White House oversight of agencies with respect to their rulemaking authority. And what I'm referencing there is President Trump's executive order that was placing agencies under his control. In that executive order, he specifically mentioned the FTC, the FCC, and the SEC. But that order would also include the FDIC, the OCC, the CFPB, and the NCUA. And as part of that, there were a number of different things that it did. But it provided that the agencies must submit drafts of regulation to the White House for their review prior to promulgating regulations. And also, the second thing was consulting with the White House on priorities and strategic plans. Now, prior to this was all really handled at that administrative level. Now, there is going to be more administration involvement at that level. There was also an adjustment to independent agencies' apportionment to, they said, ensure that tax dollars are well spent. And the final thing that I want to mention with respect to that is that the president and the attorney general will interpret laws for executive branch agencies, as opposed to those executive branch agencies interpreting the laws themselves. Now, I want to touch on just a couple of the federal agencies before I touch on state law as well. So the FDIC, here's what we have in terms of the current leadership of the FDIC. And I would say that, I'll just mention a couple of things that Travis Hill has said as he was incoming and since he's been in this position. And that is, he said that the FDIC has done a, quote, poor job permitting banks to evolve. So like where we see banks going with respect to introducing new products, partnerships with fintechs, where things are going with cryptocurrency, I suspect that under Travis Hill, there will be a lot different of an approach than what we had seen previously. Some of the things that we have seen is the FDIC had an amicus brief in the Colorado Did-MICA litigation. It supported Colorado in that case. That has been removed. They withdrew that amicus brief. He has indicated that he'd like to lay out more of expectations clearly and transparently with a focus on more public comment. So less of the enforcement through regulation. And a theme that you're going to hear with respect to the FDIC, the OCC, and some others is a focus on removing any deep banking operations. We've seen there were some activities, this could go all the way back to like Operation Choke Point. What was that, like a decade or so ago, where the FDIC federal regulators were really trying to push banks or push policy through how they were affecting banks. And we saw that a little bit with what the FDIC was doing with some examinations in bank fintech partnerships with respect to payment processing in particular recently. And really, it seems like there is a push to go back to regulation as it's written, and in some instances encourage some of those partnerships and evolution. Some specific things too that the FDIC has done, and they did this all really in one day. March 3rd, a lot of these were revoked, rescinding some of the areas relating to signs and advertising. Some of those still remain, but some of them have been revoked. Broker deposit proposal, that's been pulled back, thinking that it would affect the deposit area too much. Corporate governance, from the standpoint that they came up with a statement saying that it would be confusing to create overly prescriptive and process-oriented expectations, potentially conflating the roles of management and board of directors, and conflicting with state law too. They had in that one. So again, in the interest of time, I'm going to move to some of the other ones too. The OCC, what we're seeing here as well. So we have acting comptroller Rodney Hood. He was previously appointed during the previous Trump administration as the chair of the NCUA. That was back in 2019. Has, again, similar to what we were hearing at the FDIC, promised to remove excessive regulation from the environment and more of a focus on safety and soundness. He has been, even while at the NCUA, a proponent of fintech, a proponent of new credit unions. But I suspect that if there's a time to develop new national banks, it's now. We saw, like, one of the bullets I have here is that conditional approval of a fintech business model for a national bank. And he's also, so he's a proponent of fintech as well, and a proponent of the use of AI in banking. We did see some termination of certain cease and desist orders as well. So there's going to be a lot there. We could do a webinar on any one of these topics by itself, and maybe, Alan, we will kind of look at some of these things. But I'm just hitting on a few things high level in the interest of time.
Yeah.
The Federal Trade Commission, I just want to mention, so we have Chairman Ferguson and we have Commissioner as well, both Republicans. Democratic commissioners have been dismissed at this point. With respect to the FTC, there's been a lot of actions that have been happening. One of them is that they've removed posts that were pretty much all blog posts, I think, that were done during the previous administration. There's some questions about whether that's permissible from a record retention requirement, but anything that was in blog posts that could have been seen as an indication of rules, those have been removed. In particular, a lot of posts that were critical of large technology companies have been removed as well. Some things are still moving forward. As of now, we don't have anything on click to cancel or disclosures of fees in advertised price. That was one where hotels, concert venues have to include any fees in the advertised price. We have not seen a rollback of those items yet. So there are some things that are moving forward there. One interesting thing that affects both consumer financial services as well as others from the Federal Trade Commission is that there's a view from Chairman Ferguson that content moderation could equate to an antitrust violation. Generally antitrust, we've looked at whether it's pricing, but here content moderation could be something that's considered as well. Department of Education, a lot going on there. One of the big things that's being looked at is the transition of the student loan portfolio to the SBA. This has been looked at through executive order as well. They have also removed the online application repayment plans. There was also a court injunction on that. So it was kind of happening in combination. And we've seen, similar to other things, I had some statistics on here on some of the other commissions, just very large layoffs within the Department of Education as well. With respect to states, here's a map of where state attorneys general are, and both Republicans and Democratic state APs are active in this space. And that is very true. There are multi-state actions, that Tom is working on, other partners here are working on, and that does go across blue or red lines. I thought that the kind of where things are interesting as well. And there are state initiatives that are happening that sometimes create a dichotomy between what we see in red states or blue states, like the MCC codes for credit card processing. Texas has a law prohibiting the use of it. New York, California have laws requiring the use of it. So let me say, on the state front, I think there's kind of two groups that we're looking at. You have the state AGs. Tom spoke about the state AGs, some of the actions that are happening there. And there's a lot. Actually, at Ballard, we created a new state attorneys general consumer finance response teams because some of our clients have been hearing about things from state AGs just more viscerally than in the past. As there's something, state AGs have really decided that they need to step up where there might be a belief that federal regulators have stepped back. So you have the state AGs and state banking organizations. Within those, I think there's kind of like 4 areas that they're looking at. I think you can think of those 4 areas for both of the groups. And there I'd say, number one, oversight. And that was, I think it was Evan earlier who was mentioning that there are these signs in DC, around Union Station stuff saying that New York wants you to come work for them. And the New York DFS has been very adamant that they are expanding in this space. So, oversight, if there's this perception that there's a lack of oversight at the federal level, states are stepping up there in that sense. The second piece is, I'd say, specific consumer protection laws. That goes to what exists at the federal level. And as Tom mentioned, states can already enforce those laws through the Consumer Financial Protection Act, but they also have their own state laws that they're looking at as well. And some states are really looking at increasing some of those laws. New York right now has a proposed law that would add abusive and unfairness to their current law that prohibits deception. And it would go beyond what exists in the Consumer Financial Protection Act, and that would apply to commercial programs and a number of other things. The last 2 that I'll mention real quick is just, the third one is interest rate regulation. That's been something that a lot of states are trying to step into, to pull back the rights that really state chartered banks have, but it could affect national banks as well. There is the pending litigation at the 10th Circuit around Colorado's opt-out of DMICA. Other states like Oregon are looking at that. Iowa's been opted out for a very long time already, where that's going. And then there's Virginia. Virginia has a bill that would affect fintechs and how fintechs can advertise loans that are made by banks or advertise loans that have above a 12% APR. I just checked it right before we started. That is due to be decisioned by the governor by midnight tonight. So we'll see what direction that Virginia bill goes, because that could have significant impacts on fintech programs in Virginia. So you have the interest rate regulation. And then the fourth one I'll say is enforcement. And that is really, there might be some interaction between those state banking orgs and the state AGs. But if there's a perceived need to step up in the enforcement from the state AG perspective, if organizations are not going where the state banking regulators are expecting them to, we will see states, and we are seeing states kind of start to push towards that enforcement angle. With that, Alan, in the interest of time, I will turn it back over to you.
Yeah, let me just add a couple of things to what you said, Joseph, and then I'm going to very quickly go around the horn, and we'll probably run over a little bit, thinking maybe 5 minutes over. But the FTC, I think I want to underscore the importance of what President Trump did there in firing the 2 Democratic members of the FTC. He, under existing precedent, that termination is unlawful under both the language in the Federal Deposit Insurance Act and a Supreme Court, a very old Supreme Court case in Humphreys called Humphreys Executor. In the Federal Deposit Insurance Act, it allows the president to terminate a FTC commissioner for cause. That's not the language that's used, but I'm just shortening the language. It doesn't allow the president to fire somebody for any reason at all. However, and there will be litigation about this. At least one of the commissioners that was fired said that a lawsuit would be brought challenging the firing. Trump wants to get this issue up before the Supreme Court because it's a question, again, of executive power. Everybody, our listeners, will remember the Seal of Law case from a few years ago where the Supreme Court held that the for-cause limitation on the president's authority to fire the director of the CFPB was held to be unconstitutional under the separation of powers clause. But at that time, the Supreme Court distinguished Humphrey's executor because it applied to a 5-member commission, not a single director. And there were other bases of distinguishing it. But 2 of the justices at the time said that they would overrule Humphrey's executor. So that's the plan there. If that happens, there's concern about other agencies, including the Federal Reserve Board, where there's also language that only allows the president to remove people on boards of directors or commissioners for cause. And that's going to be a really important issue. The other final thing I want to mention is for those of you who are interested in getting more information about what's happening at the state level, make sure you listen to our webinar or repurposed podcast, where we had as our special guest Matt Placken, the New Jersey Attorney General. And then we also more recently did a webinar where our guest was Avi Malik, who is the General Counsel of the California Department of Financial Protection and Innovation. And we plan on doing more webinars and podcasts on that subject. But anyway, time now to go around the horn. Let me start with our special guests and go to Jon Hill first.
I just want to bring up 2 points, just kind of 2 data points on enforcement, just to kind of close that topic out. I think, one, to sort of give you a sense of where the current leadership's head is at. First is that the Bureau, one of the cases that they dropped, Solo Funds, this is about a peer-to-peer marketplace lender. And unusually, they removed the press release from the Bureau's website. And of course, the press releases, and often in these cases, are some of the things that companies dislike the most because they tend to use language that you wouldn't find in a court filing, and the Bureau is much freer to make allegations that come off very poorly and can damage your reputation publicly. So that's something that I found interesting. It hasn't happened in the other cases yet, but it is maybe a sense of direction about how the Bureau would announce future enforcement actions. And at the very least, it maybe opens the possibility that some other actions that could be dropped in the future could also have their press releases removed from the website. And then second data point on that is actually something that Evan was reported on. It's the cancellation of contracts for enforcement witnesses, so expert witnesses in enforcement actions. When you cancel these contracts with your witnesses, it's a signal that you probably aren't going to proceed with those cases. It makes it a lot harder to continue to litigate those cases if you don't have those witnesses on board. But just as far as what to kind of expect in the future from the Bureau, I mean, I think you'll see something that is still there, but it's going to be a fraction of its current size, or at least a fraction of the size that it was in the past few years. I don't think it's going to be the 5 men in a room at the telephone, which is a term that some employees inside the Bureau have said that they've heard leadership describing sort of the future vision for what the Bureau would be. Very, of course, in that case, a very tiny kind of agency that would just be a sideshow. But I don't think it'll be that far. I think they have appointed, or they're trying to appoint, a permanent director. But I think that it will be something that you're looking at maybe, half at best of what it's been in recent years, which was a 1,700 employee strong force. So I just think it will be a much weaker, smaller agency that tries to stick to really core activities of maintaining the complaint database, let's say, maybe doing some periodic exams for some institutions, but it's just not going to be the same in the next 4 years that it has been previously.
Thank you, Jon. Evan?
Yeah, so I just wanted to add on a little bit to what Jon had to say, in that Mark Calabria, who was the FHFA director in the first Trump administration, was an advisor to former Vice President Mike Pence. He's sort of been brought on at the CFPB as maybe eventually he'll be the deputy director, but Zixta Martinez is still there. But he's sort of taking the lead on policy issues at the CFPB. And he gave a speech at the Exchequer Club in Washington a few weeks ago, where he kind of outlined what the CFPB might look like. He said somewhere around 500 employees altogether. That might go up to around 700, depending on how litigation goes, determination of what the CFPB core functions and legally mandated functions are, sort of more restrained rulemaking, more restrained enforcement, kind of a, Kathy Kraninger diet version. But the question that I have about all of this is that Russ Vought, who is still in the administration, no matter what happens with him at the CFPB, he's the OMB director. He's very much wants the CFPB to disappear. And it was not really an accident, from what I've been told, that the enforcement actions were dropped during Jonathan McKernan's testimony before the Senate for his confirmation hearing. So I just don't really know exactly what it's, there's what the folks who are going to be leading the CFPB when McKernan takes over say they want to do. There's what the Trump administration wants to do. There's what DOJ wants to do. There's just a lot of tension there. And I'm not sure how it's all going to play out.
Let's go to John Culhane.
I don't have a lot to add here to what John and Evan have said. I kind of think of this as probably more like Mick Mulvaney's CFPB without a new shield or without changing the name, and that it'll be very limited in its activities and any enforcement actions will be very limited. I did want to clarify on the earned wage access that what Chopra pulled was the advisory opinion that said some earned wage access programs are actually legal. And he pulled that because if the proposed rule gets killed, then it would have revived that advisory opinion, which would have been standing and said that some earned wage access programs are good. Now, if the CFPB wants to go in that direction, it's not that it's impossible, but it will actually have to affirmatively issue another advisory opinion.
Okay. Thank you, John. What about Rich?
Yes, I agree. I think the Bureau will be a much CFPB light, if you will. And it'll be interesting to see, obviously the court cases may limit how much they cut back, but if they're able to really curtail its activity, the question becomes, does that bring Democrats to the bargaining table on perhaps modifications to the Bureau that would also be accompanied by perhaps some greater level of activity? Well, we'll just have to see. There's a lot of distrust on the Hill right now.
And Tom Burke. Tom Burke.
So, nothing to add in addition to what our esteemed guests have contributed.
Okay. And Joseph.
I'm going to just take a little bit of a different turn and say that the thing that scares me the most is the dust settles is state activity. I think compliance with state law, federal regulators have been the focus, and I think there's going to be a shift. And so where there has been one regulator, now there's going to be a multitude, and being prepared for that is going to take some uplift for a number of entities.
Yeah, and one of the things I think it almost goes without saying, but I don't believe for 1 second that the companies that were against whom the CFPB had enforcement litigation and those cases were dismissed with prejudice, that doesn't preclude a state AG or a private litigant from essentially bringing the same case either under federal law to the extent that it's not a national bank or under a state UDAP statute. So that's, those cases, they've gone away insofar as the CFPB is concerned, but they're not done necessarily. They're not out of the woods, because I would suspect that those cases will be vetted very carefully by the Democratic state AGs. Final thing I want to mention, and this is just a surprise to me, that the Republicans have not, in trying to downsize, or they say right size, the CFPB, they've relied upon just general executive authority to do that. And that's the issue that's been teed up in the litigation. I believe that, and for reasons that I don't know why, they've overlooked the constitutional issue that we have focused on, doing a couple of podcasts with Professor Emeritus Hal Scott who believes very strongly that it's unconstitutional, the existing funding, because it says in the Dodd-Frank Act that funding of the CFPB can only be derived from combined earnings of the Federal Reserve banks. And since September 2022, there have been no combined earnings. And indeed, there have been losses have been staggering in the Federal Reserve Bank. So I don't know why the Republicans have not gone in that direction. They still could, I suppose, but it would be a little awkward now for them to raise it. Where do I think it's all going to end up? I agree with my colleagues who earlier said it'll be a CFPB light. It will not look like the Kraninger term, because Kraninger actually brought a lot of enforcement litigation. That surprises a lot of people. But the dollars involved weren't as large, but she didn't hesitate to bring lawsuits. She brought plenty of them. I'm sort of not so sure how much activity we're going to see in the enforcement area. I'm somewhat skeptical to think that they're not going to be as active as Kathy Kraninger was. To make sure that you don't miss any of our future episodes, please subscribe to our show on your favorite podcast platform, be it Apple Podcasts, YouTube, Spotify, or anywhere else that you listen. And don't forget to check out our blog, consumerfinancemonitor.com, for daily insights about the consumer finance industry. And if you have any questions or suggestions for our show, please email us at podcast@ballardspar.com. Stay tuned each Thursday for a new episode of our show. Thank you for listening and have a good day.